great online tool that we've had a little bit of success with, and we would like to have more success having people utilize to make sure that they do have a will in place as part of their financial plan. It is not a financial plan, it is a piece of your plan, and it's something that we encourage people to regularly review. And I think on your platform, you can actually make slight changes yourself.
Yeah, so the idea is, and we'll walk through that, you can actually come back as your life changes. For example, I have a 1-year-old, so I needed to come back in after we had her and, add a guardian for her care. So it's easy to log in, make changes, and re-execute the will versus having to pay an hourly rate to a professional to do that.
Awesome. Thank you. So I think we can get started if you want, and we can jump right in. There is many people, I think, who have a code who are joining us, and some of them haven't used it yet. So I think this will be really great. And then a couple people who want the recording later because they can't meet us at this time, which is okay. And hopefully they can use it to the best of their ability.
Awesome. Well, thank you so much, Crystal. Excited to have everyone here. And I'm going to share my screen and just go through a short deck, just giving you a bit more background on myself and on Willful and a bit of the kind of basics behind creating a will. And then we're just going to dive into it. For most of you who do have a code or who are planning to use a platform like Willful, you can actually have it open on your computer in front of you, go through it alongside me. If you're not planning to use Willful, if you have a bit of complexity to your situation, no problem. As we go through, we're really just going to talk about the general things you need to know or consider as you create your will. So either way, you should leave today's session feeling more empowered to get your will done before 2023, where it ends up on your New Year's resolutions list yet again. So with that, I will share my screen, and I do want to highlight this is meant to be interactive. So please, don't have to put your camera on while you're eating lunch, but I have the chat open, I have the Q&A open, and I'd really love for you to send any questions you have. There are so many misconceptions and myths about getting your will done. So no question is a dumb question. Please share any as we go. With that, really the goal is to write your will today. That's the point of this workshop. It's not a presentation. It is a workshop that's really meant to help you get your will done. A bit more about me. So as I mentioned, my name is Erin. I'm the co-founder and CEO at Willful. And I founded Willful with my husband, Kevin, who's pictured here with me, in 2017. And like a lot of businesses, it was inspired by a personal experience. Kevin's uncle passed away, and he did have a will, but he had never discussed the elements outside of that, like funeral and burial planning and where important paperwork was stored. And so we found that our family was scrambling for answers and wondering whether we were honoring our loved one's legacy at a time when we really should have been focused on the grieving process. And about a year later, when Kevin was hospitalized for a week with septic arthritis in his ankle, he said to himself, well, I need to get an estate plan in order. I wouldn't want to have anything happen and leave Erin in the lurch. And we looked into how to get our own estate plans in order and found that it was a really traditional experience, as you may have faced when you've considered your own estate plan. It's a very paper-based process historically. Typically, you're visiting a professional and paying, 4 figures to get it done. And at the time, we were in our early 30s and pretty tech savvy, and we just didn't want to go that route, and we didn't have the budget to go that route. So we set out to build something ourselves that would make estate planning more accessible, user-friendly, help to break down some of the things that confused us during the process, and essentially just, provide an easy online way to get it done. Even though, as we'll discuss later, the law still requires that there is some paper involved, at least everywhere outside of British Columbia. I do want to highlight that I'm not an estate planning lawyer by background. I've done estate planning courses and designations, but everything I'm going to tell you today is legal information, not legal advice. So that's an important distinction. And if you do need or want legal advice specific to your situation, that's when you would want to visit a professional and ensure that you're in a lawyer-client relationship. So the first question is, hopefully if you're at this session, Crystal has already, and her team have already convinced you that you need a will. As Crystal mentioned, it's such an important part of a financial plan. When you work with a firm like Holden and Taylor, they're helping you to build your net worth while you're alive. And a key component of that is how you actually transfer that wealth when you pass away to make sure that it's efficient and as much ends up in your family's pockets as possible. And that's the thing about a will. It is for your family. It's not for you. It provides a blueprint that they can follow. And it removes the guesswork and arguing that I highlighted existed in our own family when we lost a loved one. It also just practically, it cuts down on the length of time it takes to administer and settle an estate. Usually that's about 12 to 18 months, even for a simple, very organized estate. So it's a very time-consuming process. It also avoids the government and the courts making decisions. If you pass away without a will, in every province, there's a formula that dictates how your assets would be distributed. A lot of people say to me, well, I don't need a will because everything would just go to my spouse anyways. But in Ontario, for example, half would go to my husband, Kevin, and half would be tied up in a trust for my 1-year-old daughter until she turned 18, which is definitely not what I would want. So it's really important to understand how that government formula would distribute your assets. But a will also just isn't about asset distribution. A will appoints an executor, as we'll get into, who will bring the wishes in your will to life. It also appoints guardians for minor children and pets. And if you don't have a will, the courts are going to appoint people to act in those roles. So having a will just means you're in the driver's seat, but ultimately it's like life insurance. You never benefit from it. It's always going to be your family that benefits from it. I also wanted to highlight what's involved to make a will legal in Canada. Often people reach out and they say, wait, online wills, don't I have to visit a lawyer to get my will done? And listen, how you choose to get your will done is up to you. The point of today is that Crystal and her team want you to get a will. It's important that you have one for your financial plan. How you choose to get one is really up to you. I'm obviously going to be walking you through our platform, but you can write a will yourself on a piece of paper in every province except BC and PEI. You can buy, you can go to a lawyer, you can use a platform like Willful. What's required to make it legal in Canada is that it's written by you, so you can't create a will for someone else. You have the mental capacity to understand the decisions in the will, and that you sign it on paper in front of 2 witnesses who also sign the will on paper. If you're in British Columbia, you are the only province where you can do this online. So you can electronically sign and witness and store your will. Everywhere else in Canada, it's still physical paper. And unfortunately, COVID was a catalyst to change and move some things online, but still some paper involved. So that's what's required to make a will in Canada. And with Willful, we'd really tried to make it as easy as filing your taxes on TurboTax or ordering a meal on a meal delivery app. We're really trying to eliminate the need for in-person appointments. We streamlined the process online, as I'll take you through, and most people complete in under an hour. As you'll see as we go through it, I'm going to pause to highlight some information, but if you just, went through the process itself, it would take 15 to 20 minutes. So there's really no excuse to put it off, knowing how meaningful this document can be to your family, which is why we're so committed to helping you get it done today. In terms of Willful, we've been around for 5 years. We've helped Canadians create over 100,000 documents across 8 provinces. We have really awesome reviews on Trustpilot if you want to go check them out. And we even scored a deal on Dragon's Den. So that was a pretty fun experience. Not what we're here to talk about today, but we did go through with the deal with Michelle Romano, and she is now one of our investors. And I forgot to mention, we actually last week became the first online will company that has been licensed by a provincial law society. So the Law Society of Ontario has given us a license, which means we don't need that license to operate, but we can now offer legal services like lawyer services in addition to our online will services. So that was a pretty exciting day for us at Willful. And as a part of that, the Law Society thoroughly vetted all of our documents and our platform. So it also just gives you peace of mind that the country's largest provincial regulator has put their stamp of approval on Willful.
So that's exciting. It actually came up a few times.
Oh, did it?
Yeah, people recognize it, that you are Now famous. Congratulations.
Oh, well, that's good to hear. And yeah, we are very proud of that fact. And, you know, as part of that, we also have to provide ongoing reporting and make ongoing improvements to the Willful platform. So yeah, it was a big milestone for us. And I'm going to come back to some of the next steps at the end of the hour in terms of what you were going to speak to, Crystal, and I'll move over to the demo, if that makes sense.
That sounds great.
Heather asks about, is Willful recognized in the Yukon? Great question. Not yet. We are working on expanding to our remaining provinces and territories. So the only places we're not active are the territories, PEI, and Newfoundland. So that's partly because we take the approach of partnering with a local law firm to help us with drafting all of the legal content so it adheres to provincial regulations. And we have them on contract with us to keep that content up to date as laws change. So as we kind of build those partnerships with local firms, we will be launching in additional areas in 2023. Okay, so I'll stop sharing that and I'm going to shift over to actually doing a demo of the Willful platform. So whether you're going to be a Willful customer or not, whether you're going to use the platform or you're going to visit a professional, open up the site, go to app.willful.co. If you already have an account, you can log in. If you don't, I'll walk you through signing up. I'm just going to reshare my screen on this revised window. And again, even if Willful may not be a fit for your situation, you can also kind of go through the steps on Willful just to help you make decisions. And if you decide not to go with it, you can always delete your account down the road. So you're going to first visit when you visit. I'm on our staging site just so I don't create a real account on the front end, but it's the same experience that you'll go through. So if you go to app.willful.co, you'll visit this page here. Now, we do have a link for you to receive a discount with Holden Taylor. So we can make sure that you have that. We'll send it out after the webinar, or maybe Crystal can put that in the chat so you can click that. And I'll show you what that does when you click that. The first thing you're going to do is just enter your email. So I'm going to just enter an email I hopefully haven't used before. And of course, use a secure password. And then you're just going to create that account. The great thing about Willful is that you don't have to do it all in one shot. You can save your progress as you go and come back to it, because the thing about estate planning is there's lots of decisions that you have to make as you go through the process. I do have the link handy here, Crystal. I'm just going to grab it and throw it in the chat.
Thank you.
No problem. So just give me 1 second to grab that. So if you click on this link, it will automatically apply, I believe it's a 15% discount to Willful services. And I know Crystal's going to share a bit more at the end about some other steps that you can take.
Oh, I think it's 20. Yeah.
20. Okay, perfect.
Yeah.
So if you click that link, it's automatically going to apply that discount for you. There's no need to enter a promo code or anything. And as you can see on the screen here, this is just saying Demo Inc. to show you what it's like once you click that link. But it'll pop up and show you, okay, this is the discount you have, and you have 45 days to actually check out and make your purchase with that discount. After 45 days, it's just going to remove it from your cart. So as I mentioned, if you want, you can pay and check out with that discounted rate at any time and finish your documents at a later time. It saves your progress as you go. And, a lot of people do have to pause as they go to have discussions with loved ones or with some of the people they want to name in key roles. So if you're following along, let me know if you have any questions as you go, or if there's any issue with opening this up. You will see that that discount is still reflected here in this banner. I'm just going to X out of it as we go through. So you can see here, it pulls in some of our recent reviews that you can read, and it's going to tell you exactly what we're going to do. We're going to create our legal documents from the comfort of home. So as I go through, I'm going to walk you through every step and just annotate some of the nuances behind each of these decisions. And again, I want this to be interactive. So if you have questions as we go through each section, feel free to let me know. So there's 5 sections on Willful. The first section is all about just getting some details from you that will help us understand which plan is the right fit for you. And we'll also tell you kind of why we're asking for each thing, because a lot of times it's used in the legal document itself. This is what we call our warnings page. And it's really important to us that the people using Willful, it's the right fit and that they know and understand the nature of Willful. So, I've already highlighted this to you. This first point, we work with estate lawyers. We guide you through creating your own legal documents. These documents are not reviewed by a lawyer. So, it's really up to you to make sure things are spelled correctly and that you're putting in information that's accurate. And we're going to guide you through reviewing your document at the end of the process and making sure that that information is correct. We're not a law firm, so if you do want legal advice or tax advice, then that's where you can work with a financial planner, or you can visit a professional. And of course, you have to execute the documents to make them legally binding. They are not legal until you have signed and witnessed them according to our instructions. And then we also give some examples of situations that Willful may not be a fit for. So for example, if you're remarried and you want to create a spousal trust to protect some of your assets and make sure that they go to your children, that might be something you want to chat with a lawyer about. We don't help with kind of tax minimization strategies. If you have a dependent with a disability, that's not something that we can accommodate. Or if you want to disinherit someone. So for example, if you wanted to leave someone out of your will and you think that they might challenge it, you can work with a lawyer to put language in the will about that. And that's not something that we can accommodate on Willful. If at any time you're going through the platform and you're not sure, is this the right fit for me? You can always pop over to this little box in the bottom right-hand corner. This is a bot that's going to help you with any content. So you can see, for example, here, if I'm separated but not divorced and I want to know the impact of that on my Willful will, I can type in the word separated and it's going to surface a bunch of content from our Learn Center and Support Center that might answer your question. If that doesn't work for you, if that doesn't get you an answer, you can also request a call with our team and we're happy to call you on the phone to chat through, or you can live chat with us during business hours. So I'm not going to do that live chat now, just in the interest of time, but you can see the links here to do that. Request a call back, send a message, and you can also link to any of the articles in our Learn Center, just in case you want to do a bit more reading before you get into the will. Let's assume, though, that we're going to move forward. We're going to start with where you live. And this is important because, as I mentioned, we work with lawyers in each province. And when you select that province, in our back end, we have a different will, different copy, different content for each province. So if you ever move provinces in future, it's also really simple to log in, change your province, all of the content updates on the back end. And then you just re-execute the will to make that new will legal. And I'll speak to that a bit later. In terms of city, the city is referenced in the will. I'm actually in Prince Edward County, Ontario. So I'm going to put in my actual province. Phone number is optional. This is something where we might be doing some outbound calling to folks in the future to see if they have questions or to highlight new products that we might have in future. But of course, that's optional. And you'll notice as we go through, we have these blue boxes that really try to explain why we're asking for things or give you helpful information. So you can read those as you go through. Next, we're going to get your full legal name. I like using celebrities as I go through this. So my name is going to be Jennifer Aniston. Your legal name is used in the will itself, which you can see over here. My date of birth, this is to understand if you're over the age of majority in your province, because only adults can make wills. There are some exceptions if you're in the military or if you have a child with someone, but generally you have to be an adult to make a will. The gender page is just more for us to understand who are the people making wills, how can we best empower people with the tools that we have, but you can say prefer not to say if you'd like. So that's section 1. Again, just getting a few of the key details that are used in your will. At the end of every section, you're going to have this opportunity to review and to edit. So if anything's spelled incorrectly or you need to go back and change it because you made a mistake, you simply click edit. If my name was spelled incorrectly, or if I wanted to add a middle name, let's say, I would just press continue. And then it would just bring me back to that section summary, and I can make sure that it's all correct. When I'm happy with my answers, I can say looks good. And that's just going to show me that I've made 19% progress already. And it's going to guide me through choosing a plan next. So section 2 is choosing a willful plan. First, it's going to ask, who are you actually creating a will for or with? Again, you have to create a will. Each person needs a will. It's like tax returns. So if I'm married, I need a will, and so does my spouse. And that's because we will likely pass away at different times, and we each have our own individual estate. So I'm going to choose just me today in the interest of time, and I'll walk you through a little more of our plan options in a moment. Then it's going to bring me to this page where it's going to recommend a plan for me. Our premium coverage plan is our most popular plan. This is a plan for an individual. It comes with a will and both power of attorney documents, as well as a couple other features, which I'll guide you through later. This is typically $189, but because of the discount that you have, it's $151.20. If I wanted to see other plans, I can do that. We have 3 plans in total. The legal essentials comes with just a will. The premium coverage, which is the one that was recommended for us, has the will and both power of attorney documents. And the plan on the right, the family plan, covers 2 adults. You'll notice here there's a drop down. So I had someone reach out yesterday that said they wanted to buy wills for their 2 adult children and their spouses. In addition to them and their spouse, 6 people total. So they can just choose that option. Once you purchase the family plan, you go through the process of creating your will, and then you can invite your spouse or whoever else you want to invite to create their plan. Each person does get their own individual account because, again, wills are individual and they also have sensitive information. So we want each person to have their own account. I'm going to go back and choose that premium coverage plan that was recommended for me. And now you can see my progress is at 24%. I'm not seeing any questions here, but if you do have any, or you need me to slow down or clarify anything, please let me know. If you're following along with me, then you should be at section 3, your family. This is when we really get into the meat of the decisions in your will. And I will answer that question about power of attorney documents when we get to section 5, your arrangements, which includes powers of attorney. So the Your Family section is all about understanding if you have a spouse so that we can understand whether we need to ask if they're going to be appointed in key roles, and getting some info about children and pets. The big difference between a platform like Willful and a paper will kit that you might find at Staples is the paper will kits are one size fits all. They don't care if you have pets, dogs, spouses, or you're single, the document's still going to look the same. Willful's different. If you tell us you're married and you have children and you have pets, you're going to get a different series of questions and a different resulting document than if you're, single with neither of those things. So that's really the big difference. And when we're asking you these questions, we're trying to understand, what do we need to ask you later? What do you need to do in your will based on your life situation? So let's say that I'm married. In my, and actually one thing I should note, I have common law here as an option. In provinces, including BC and Ontario, if you pass away and you're in a common law relationship, that government formula I talked about does not account for common law spouses. So your common law spouse would get nothing. They would have to appeal to the court, and hopefully the court would give them some of your assets, but it's up to their discretion. So if you're common law, it's even more important to have a will. Now you'll notice that separated isn't an option here. If you're separated but not yet divorced, the law still considers you to be legally married. So it's important to know that you have a separation agreement that clearly says that that ex is not going to have a right to your assets. Otherwise, you may want to work with an estate lawyer to write that language in. But let's assume that I am just legally married. Now, I'm going to go back to the 90s, and I'm going to wish that Jennifer Aniston was still married to Brad Pitt. So I'm going to list Brad as my spouse, I don't know how old he is. Let's pick 2011 might be a little young. 1989. I know that's wrong, but that's okay. And again, we're going to ask the gender question, and you can, click prefer not to say if you'd like. Now we're going to ask you if you have children, and this is to understand if we need to ask you to appoint a guardian for their care. I have a question here. What if you haven't formalized your divorce and you are common law? So good question. If you are separated from someone and you're living in a new common law relationship with someone else, number one, the law typically doesn't recognize you as common law until you've been living with someone for 2 years. The definition of common law changes by province. We have an article on our Learn Center, which is willful.co/learn, and it outlines what common law is in each province. But if you are separated but not divorced and in a new common law relationship, again, if you passed away without a will, that common law spouse wouldn't be entitled to anything in some provinces. In others, they do account for common law spouses. And either way, you would want to have a separation agreement that clearly says that's separate from the will. That's typically done with a family lawyer that says, my ex Joe is not entitled to any of my stuff if I pass away. Once your divorce is finalized, the law says that they wouldn't be able to benefit from your will, even if they were named in your will. And also a pro tip, if you ever get separated or divorced, you want to update the beneficiaries on your life insurance policies and registered savings accounts. No one wants their life insurance proceeds going to their ex. Maybe you do. Maybe you have a really amicable divorce. Most people won't.
And on your group benefits, we see that all the time when we ask people to send us their statements just to review as part of their plan. And I got one recently. I was like, I haven't been with that person for 13 years. And that money would have gone to that person. So.
Yeah, it's unfortunate. And it actually leads into Beth's question here. Sorry. Beth asks about the assets like joint bank accounts. And this is a really great clarification. People often say, I own my house jointly. How should I leave it in my will? So there are assets that are covered by your will, and then there are assets that sit outside your will and don't flow through it. So for example, jointly owned assets. I own the house I'm sitting in with my husband, what's called jointly with rights of survivorship, which is the most common type of joint ownership. If I passed away, the house would just transfer to him. And it would not flow through my will. Same with our joint bank account and any joint investments that we have. One caution is parents and children. If you, let's say, put your adult child on the title of your home, the law says that it doesn't assume you actually intended that home to go to them. So you typically need to write a letter or do something else to show that intent. Won't get into that today, but Crystal can probably help with that if you have questions about it. Then we look at things like registered savings accounts, pensions, and life insurance policies. Typically, all of those have named beneficiaries directly on them. So I've named my husband as the beneficiary on my RRSP. Same with my life insurance policy. Those are going to go directly to him. They're not going to flow through my will. The reason that that's beneficial is because number one, they're going to pay out way faster. Life insurance takes 2 to 3 weeks to pay out versus a will, which takes 12 to 18 months to close up and pay out to beneficiaries. And the other reason is you don't have to pay probate fees. When you pass away in each province, most likely your will is going to have to go through probate, which is the process of going through the courts to accept the will and give the executor legal authority. And there's fees associated with that. In Ontario, they're 1.5%. Well, that's expensive, especially if you have a big life insurance policy. So a lot of people appoint individuals versus the estate on those policies to avoid those fees and to get money into their hands faster. So thank you, Beth, for that question. When you pass away, everything you own that is not jointly owned or that doesn't have a beneficiary already named on it would flow through your will. I'll continue on here in the interest of time. So I'm going to say that I have a child, even though Brad and Jennifer never did. Let's just call them Samantha Pitt and Right now, we don't have the ability to add unborn children to the will, but that is something that we're looking at adding in future. So when I had my daughter, for example, I just logged in, I came to this section, and where I didn't have kids before, I just added her. That automatically triggered the system to go on and ask me about guardians and add them. So that's as simple as it is. When you need to make a change to your will in future, you log back in. I'll show you where to do that in your account. You come to a page like this, you add the relevant information or change the name of the person that you wanted to remove from a role. And then you just press continue and it's reflected in your will. So it's super simple to keep it up to date. I'm going to choose guardians. Now, I know, George and Amal are probably pretty close with Brad Pitt. So I'm going to leave, them as the guardians. Now, the key is I've talked to them about it because not everyone wants to become instant parents. So very key to do that. You can add an individual or a couple as a guardian. And you can also, it's best practice to add backups. And that's for every role as we go through Willful, from guardians to executors to beneficiaries. So I'm going to add a secondary guardian. I feel like Jennifer Aniston's pretty close with Oprah. So let's add Oprah as the secondary guardian. When you add a guardian in your will, it only comes into effect if you and the other parent are not around. So if I passed away, my husband would just continue to parent our daughter. And this is, often the most contentious part of your will, because you and your spouse or you and the other parent may not agree on this. So it doesn't have to be a perfect decision. You can always come back and make updates in future, but make sure to make a decision. And when you name a guardian or even an executor, they don't have to accept that role. They can turn it down. So that's why it's important to put secondary folks in place. So for example, if George and Amal say, you know what, we're pretty busy being rich and fabulous, we can't do it anymore, then it would go on to Oprah. Let's say I didn't appoint a secondary guardian, that's where it would go to the courts, and the family court would actually make that decision and appoint someone. So definitely best practice to appoint primary guardians and primary executors, as we're going to do later, and secondary, and even you can add as many backups as you want. So if you have any questions about guardians, please send them through. Otherwise, I will keep moving. Do you have any pets? So, one of the biggest feature requests we got when we launched Willful was the ability to plan for pets. Unfortunately, owners not planning for pets is one of the #1 reasons pets end up in shelters, because their owners pass away and they haven't actually planned for someone to take on their care. So on Willful, we allow you to do 2 things. Well, first, I'm going to ask about the details of Fido, my dog. I can add as many pets as I want. And then I'm going to choose pet guardians. For me, I'm just going to choose George and Amal because they're also taking on my kids. Why not add a dog into the mix? I can add more backup guardians if I'd like. In this case, in the interest of time, I'll just continue. I can also leave money for their care. So for example, I might want to leave $5,000 to George and Amal if they assume the care of Fido, my dog, because I know that Fido is prone to eating stuff and they're probably going to have some vet bills. So this is an optional part of the will, and you'll see on Willful that there are sections that are optional. So you don't necessarily have to. Maybe these sections are mandatory, but you can just say no pet trust. So for example, you would just say nothing. And then you can review your answers. There are sections later in the process that are optional, and I'll highlight those. So again, you're just going to get to the end of that section summary, and you're going to review all of your answers to make sure that they reflect your wishes. And if they look good, you're just going to say, looks good. And now you'll see that you're at 52% progress. You can see here that we have a call to action that says, not ready to complete your will. That's okay. You can check out now and come back later to complete your documents. So if you had to run out for some reason and you weren't able to finish the other 2 sections, you can click check out now to pay. Your progress is always saved in your account and you can come back later. And again, we're also going to highlight the ability to get in touch with our team if you have any questions. Now we get into the important task of appointing beneficiaries. This is one of the 3 key decisions in your will. The first key decision, appointing guardians for minor children and pets. The second key decision, appointing beneficiaries to receive your assets when you pass. Third key decision, appointing substitute decision makers, your executors and attorneys and your power of attorney documents to make decisions for you. So beneficiaries. We start by asking you about specific gifts. You might have also heard the term bequests, but basically this is an item that you want to leave to someone or a cash gift versus a percent of your estate, which we're going to do a bit later. So this could be items of value. So for example, I can leave $5,000 to George Clooney. I really like him. Oh, first name, I'm going to double check. Got to make sure my info is correct because there's not a lawyer who's going to look over this after. So it's up to me, make sure that it's correct. But it can also be sentimental things. So I'm just going to say, grandma's recipe book. And I'm going to leave that to Oprah because I know she loves to cook. You may have none of these gifts. You can see here that you can skip, or you might have 20. In my own will, I've left my wardrobe to my sister. I've left my guitar to a friend who's very musical. I've left some of my art to a friend who I know really appreciates art. So this is something that you can think on. And again, if you have, RRSPs or other accounts like that, typically you would appoint a beneficiary directly on those accounts. So if anyone has any questions about specific gifts, let me know. Again, cash or items that you want to leave to specific people. After that, one of the things we're very passionate about is actually Giving Tuesday today. So it's very serendipitous. We're doing this session today because one of our core missions at Willful is to help encourage gifts to charities and wills. So we encourage everyone who comes through to consider leaving a cash gift or a percent of their estate to charity. Obviously, this is completely optional. You allocate your estate however you would like. In my will, I sit on the board of Save the Children Canada. So I've left a cash gift. It's as easy as scrolling through our list of preferred charities. You know what? I'm actually going to leave it to the Hospital for Sick Children, which I'm also involved with. I'm going to leave, $5,000 to them. If you don't see the charity of your choice in that drop-down list, you can actually just add it manually, and you can add as many donations as you'd like. Again, this is optional. The reason people like leaving gifts to charity is it reduces your final tax bill. So your estate gets a tax receipt for this amount and reduces the taxes that you're going to have to pay after you pass. What happens if a charity no longer exists? That's a great question. So typically our clause in our will says that if the charity doesn't exist anymore, that the executor has the discretion to direct those funds to a charity that reflects my wishes. So if I left something to the Humane Society, obviously I care about animals. And so they could decide to leave it to, to direct those funds to another animal rights charity if my chosen charity was not around at that time. So then we get to this meaty part, which is allocating your estate by percentage. So what's going to happen is when you pass away, your executor is going to, file your final tax return, pay off all your debts, file your final tax, I already said tax return, pay all of your estate expenses like funeral and burial costs, or the cost of working with a lawyer or accountant, etc. Then they're going to distribute those specific gifts or cash gifts to charities like we just went through. And then everything that's left is called your residual estate. It's hopefully a big pot of assets. Let's say it's $500,000. In this section, we are going to divide that up by percentage. So first, it's going to ask me, if I pass away first, do I want Brad Pitt, my husband, to receive everything? If you don't have a spouse, you're not going to see this question. If you do have a spouse, it's going to ask, do you want your spouse to receive everything? So I'm going to say, yes, I do want Brad to receive everything if I pass away first. Or you can say, no, he will be one of many beneficiaries. Either way, it's going to guide you through the next step. Okay, well, what if me and Brad both pass away at the same time? Then how would I want to allocate my estate? Well, for me, I know that I want to leave everything to our child. And so I'm going to add her name in there. And then you'll see as you add beneficiaries, it gives you this nice little pie chart that shows how it's broken down. You can either add more people or more charities, and it's always just going to add up to 100%. You can have one person at 100. You can have 10 people at 10% each, totally up to you. In this case, I'm going to leave everything to, you know what, actually, I'm going to add George Clooney. He's just my BFF. So I'm going to add him there. And then you'll see that it defaults to 50-50. Well, I don't want it to be 50-50. I want my daughter to receive 90%. I want George to receive 10. Now you'll see if I try to add it up to more than 100, it's going to give me that error message. So we have all of this logic built in to make sure that you're not making common errors with printed will kits, like over allocating your estate. So it's always going to make sure it adds up to 100%. And as you can see here, it's a nice little visual representation of who is getting what. I'm going to continue on here, but again, you can play around with this, add as many people as you'd like. And remember, this is only in the event that me and my spouse have both already passed away. In the event I just pass away first, my spouse is going to get everything. But now it's, what we're doing is we're walking you through the what ifs. Okay, Erin, you've said that you want Brad to receive everything when you pass away. What happens if you and Brad pass away together? Okay, you want your child to receive everything and George Clooney to get a little bit. Well, what if George Clooney passes away with you, or he passes away and you forget to take him out of your will? What should happen to his share? And we give you two options for that. Either it would go directly to George's children if he has them. If not, you can divide it amongst the others. In my case, if George isn't around, I just want my daughter Samantha to get everything. So I'm just going to say divide amongst the others. Now we are working on more flexibility here. So you could say, if George passes, give it to Oprah. If my daughter passes, give it to my best friend. Right now, we have these two blanket options that apply to all beneficiaries. But the great thing about Willful is we're constantly adding more features and functionality. We always email our customers when we add those things, and you can come back and make changes for free at any time. Now, the final step in your beneficiary section is naming a contingent. This is very simple. Think of it like a disaster clause. If every single person you named in the previous section was not able to receive their gift because they've passed away or they passed away at the same time as you, who would get your estate? This is an optional section. So if you don't want to name anybody, you don't have to. This is where a lot of people choose charities, siblings, parents, etc. I'm going to be nice and I'm going to say I want 100%. We were talking about animals. I want everything to go to the BC SPCA. So this basically says if me and my spouse and our daughter and George Clooney and his kids are all not around, the BC SPCA would get everything. What we're trying to do is stop it from defaulting to that government formula. We're adding in a bunch of layers, as unlikely as it may seem, just in case. So hopefully that makes sense. After you've done that, you have, one last step. If you have minors, so for example, I mentioned my daughter's 1 year old. Well, if my daughter was to inherit something right now, it would be held in a trust that's triggered by Willful and managed by my executor, who also acts as the trustee for that money. So let's say $250,000 ends up in a trust for my daughter. This page is saying, if you do have any minors that inherit something from your estate, when should they receive that money? When they're eligible, AKA 18 in Ontario, age of majority, or at a different age. Well, I don't know about you, but I would have not been responsible with a bunch of money at age 18. So I'm going to say that I don't want my daughter to get it until she's, maybe I'll give her 50% at 25. And again, you can see here that logic that's built in. It knows that I haven't added 100%. And I want her to get the rest when she's 25. 25 seems like a very mature age. Now it adds up to 100. But you can default to, just when they turn 18. But people really love this, especially all the financial planners that we work with, because they've seen so many situations where, kids have gotten large inheritances when they're young and not been responsible with them. Okay, so that is the kind of bulkiest section of willful. It's one of the most important in that it's deciding who gets your stuff. Again, you're going to review all of this and make sure that it reflects your wishes. And when it looks good, you're going to move on. You can see that we only have one section left, which is going to take us 3 minutes. So simple question, who do I want to be my executor? I already talked about that role and what they do. They're the ones that are bringing the wishes in your will to life, closing up your estate, paying your final tax bill, distributing assets to beneficiaries, etc. It's a big role, and you want to choose someone you trust who has the capacity to do this. We do not accommodate professional executors right now, though you can, with a lawyer, choose a trust company, professional executor, or lawyer to act in this role. It's very common to choose your spouse, sibling, a friend, parent, etc. Because I've said I've had a spouse, it's going to ask if I want my spouse to act in this role, and my answer is yes. But we already talked about the importance of backups, so I am going to add a backup executor just in case. In my own will, I've appointed my husband, Kevin, as my executor, my sister and my mom as the 2 backups. Here, I gotta go George. I've been going George the whole time. He is my backup. And you know what? Just in case, I'm gonna add a 3rd backup. And that's simply because, again, they don't have to accept this role. So the more backups I put in place, the more likely it is someone's gonna say yes, and it's not gonna default to the courts. Now, we do have funeral and burial wishes included in willful. These are optional. So if you don't want to decide right now, you can just skip them. But most people don't talk about this in their will. So I'm going to choose cremation. It gives you some information on pricing. I'm going to let my family decide what I would want done with my ashes. And I'm going to choose a funeral for my ceremony. Again, these are optional, but it's just to give your family an indication in case you don't actually talk to them about it. Now, we had a question earlier about powers of attorney. So as I mentioned earlier, there are 2 types of power of attorney documents, one for finances and one for healthcare. These documents appoint someone who's going to make decisions about your finances and your health for you if you are incapacitated due to illness or injury. This is not the fun one. This is the, if I'm in a coma, if I was in a car accident and I needed someone to, act on my behalf, who would that be? It's very common to choose the same person as the executor, although it can be anyone you'd like. There are different names for these documents in each province. So depending on the province you're in, you might see a different name for the document. But it's going to ask me, do I want my spouse, Brad, to act in this role? My answer is yes. And then again, I can add those backups. If you're not sure what this is the explanation of it. This is the person who makes your financial decisions. They can pay bills for you, etc. The other type of power of attorney is for your health care. In Ontario, it's called the power of attorney for personal care, but it might be called a healthcare directive in your province. In BC, it's called a representation agreement. Basically, who's going to make healthcare decisions? I'm going to choose the same person in this role. I'm going to choose my spouse, Brad. You can choose different people if you think one of your family members is more financially savvy and the other one you want to make healthcare decisions. And then we're just going to ask you a couple questions about medical treatment. If you were unable to communicate what medical plan should be followed, you can skip this, or you can say, let my attorney decide. Withdrawing treatment versus staying on life support is something some people have really strong opinions about. I'm not going to get into detail with this today, just because we only have a few minutes left, but I'll just say that I'll let my attorney decide. So that brings us to the end of the process. We've gone through all of the sections, and as you see from the confetti here, we are done. So hopefully you've been following along with me and you are also at the finish line, but we're not quite done in that we need to pay for our documents, and then I'll show you how to execute them before we sign off for today. Crystal, I can go a little bit past the hour if you wanted to stay on a bit, because I know it's been a lot to get through. There's always so much to talk about with estate planning. When you get to this checkout page, you're going to see that 20% discount has automatically been applied. You'll see that that's reflected in the total there. And I'm just going to go through and process my fake credit card payment. I encourage you to use a real credit card. And I'll show you what happens after that. So once you've paid, it is going to unlock your documents. We do have a 30-day money back guarantee. So if for some reason you change your mind about Willful, no problem. You can just reach out to our team anytime. Once you've confirmed, you see that your next steps are to download and print your documents. So here you'll see your documents page. I'll open one up in a moment, but I'll have to switch my sharing screen. So we first wanted to show you, okay, this is your documents page. Every time you come back to Willful, you can find your legal documents here, your will, and each of your power of attorney documents, 3 documents total. But we also have this great asset list document. So I'm just going to show you a few other things you can do in Willful. Asset list allows you to make a list of all of your assets and liabilities, like your bank accounts, any loans or credit cards that you might have, any life insurance policies. And the goal of that is to save it alongside your will to help your executor out, to give them the details for your financial planner, to tell them who your insurance broker is. So you can see that you can go through and add, property and vehicles. Let's just do, family, home. And this is really going to help with things like, is there a mortgage, etc. And once you've added this, you can then generate that beautiful asset list and print it and store it alongside your will. I'm going to quickly show you how the document actually looks. So let's just open that up. I think you should still be able to see my screen with this document loading. So after you're done your will, we generate this PDF document for you with a clear instructions page. So it outlines how to review the document, and then it goes through the requirements for signing and witnessing. In every province except BC, you're going to print the document and sign it in front of 2 people who are not beneficiaries of the will or their spouse. And those witnesses are also going to sign the document. The great thing about this instructions page is it actually tells you who cannot be a witness to your will, because that's a common mistake that people make. After you sign and execute the will, you're going to store it in a safe place in your own home or in in wherever makes sense to you. You're going to let your executor know that you have created the will. And again, you're going to keep the document up to date by coming back to Willful, logging in, making changes, and going through the process of executing that new will, which automatically revokes the older will, and you can destroy it. So I know I breezed through the last little section there. I'll hand it over to Crystal because I know we're right at the top of the hour, and she had some info that she wanted to go over for you. And then if you do have any other questions, I'm happy to stay and answer them. So Crystal, over to you.
Thank you so much, Erin. I really appreciate you stepping in and helping us with this today. I know that you're a very busy person. You've made such huge improvements to the platform. It's constantly evolving. You can follow them on social. It's really exciting. As a planner, it's really hard to get people to take action. So I hope this has really helped you take action and at least get a will. Whatever format works best for you, something is going to probably be better than nothing because you get to have your say. And that's really important to us. And it's really important to the people around you. So that is really helpful. If you want to reach out to us, we have some codes available for the people who have attended today. Of course, it doesn't work in the Yukon. I'm so sorry. I'm really hopeful that it does soon, because in the Yukon, it's really challenging. I have family, friends, and clients up there, and it's really tricky to get wills done there. The lawyers are very busy. So
I will also say, sorry to interrupt, Crystal, our friends at legalwills.ca are available in the Yukon. I know Tim and the legalwills.ca team very well. Also another great online will option, and they are available in the territories.
I'm writing this down because I really want to go check it out after and make sure that I send that out to a few people who couldn't attend today. So that's really helpful. Thank you.
Perfect.
And I would love to know the process of executing your Willful, because I have a couple of people who have done it and not executed it yet.
Yes, that's very common. So essentially, we're going to give you those PDF documents, like I mentioned. All you have to do is print them, sign them in the presence of 2 witnesses, who also sign the document. Once you've done that, it's a completely legally valid will. And we provide that instructions page that tells you how to do that. If you don't have a printer at home, you can ask a friend or family member, or most Staples locations or any copy shop would have a printer where you can get that.
If you're in Calgary, you can ask us. We'll help you out. We want to make sure you guys have it available to you and make sure that it actually gets put in force. That's so important.
Yes, and it's common. I mean, listen, procrastination is common. We saw Erin Carter, the singer, pass away recently, and he was 34 and he didn't have a will. And, I meet people every day who are in their 20s and 30s or even 40s and 50s who say, I don't need a will. I don't plan to die for a long time. Well, nobody does. The point of an emergency plan is it's in place before you need it. And whether that's your will, power of attorney documents, an emergency fund, life insurance. These are not always the most fun things to think about, but they're the things that set you up for success, and more importantly, set your family up for success. So that's the point of the session today, is take action. Hopefully you were following along the process. And even if you're not using Willful, you have some of those decisions made. But I challenge everyone here, get the will done by the end of the year. You don't want to go into January having this on your resolutions list. And if you're here, it's because this has been on your list for years and Crystal and her team have been bugging you. So take the half an hour, open a bottle of wine, chat with your spouse, your guardians, whoever it is you need to, but it's also not as daunting as you think. Hopefully I've showed you today. Now I chatted the whole way through the process, but if you actually knew the decisions and just sat down to do it, the entire process from making it to signing the documents and making them legal would take you half an hour.
Yeah, I've heard it as little as 20 minutes for some people who are, my age, and they had a simple situation. So that's been really fantastic to know. Yeah. Thank you so much. I really appreciate you showing up for us today. It was really helpful to go through that because in my position, it's just not a tool that I can use at the moment, but I really think it's appropriate for so many people. So thank you very much.
Absolutely, no problem. Is there anything else you wanted to highlight on this slide, or should I thank everyone? And
I'm good. I think everybody knows how to reach out to us. So hopefully, if you're here today, and we'll send you all a note. We'll save the chat. I don't think we've missed anything in the questions. I don't see. Oh, maybe there's one more. Oh no, I think we're okay. So I think we're ready to call it a day, and hopefully we see some people putting these in force before Christmas, and they can enjoy the holidays and start the new year having that item checked off your list for the year.
Yeah, peace of mind is the best Christmas gift in the world. So Crystal, thanks so much. We love partnering with Holden Taylor, and we really appreciate you inviting us, and I hope everyone has a great rest of your afternoon.
Thank you. Thank you, Erin. Have a great day, everybody.
You too. Bye.